So please take your seats and let me turn it over without further ado, please, to Anna Rappaport. Go ahead.
Good morning, everybody. It gives me great pleasure to moderate this closing panel, and I know the closing panel has traditionally been somewhat of a roundtable where we've tried to understand and build on what we've heard. We're going to do that as well as bringing you, we hope, some real insights about these fiduciary issues. Our panel is titled Fiduciary Challenges for Financial Advisors, and I will start by, for those of you that don't know me, just pointing out that I'm an actuary and certainly not an expert on these issues. In teeing up the subject, though, I think it's really important for us to remember that retirement savings can be found in pension plans, in individual retirement accounts, and other personal savings. And we need to remember that those include housing values, and human capital is important in terms of building resources for retirement. We need to remember that the employer is important in savings. Many people wouldn't save without an employer plan and save even less than they do today if they didn't have it. There's a lot of money in individual retirement accounts, but much of it came through rollover, so the original savings was not an employer plan. Our panel will provide some insights about what fiduciary requirements mean to the retirement system and their real-life impact. I think what's important to understand about our panelists is that each of the panelists is involved in helping some system stakeholders understand and meet those rules. And the rules are really complicated to meet. I mean, it sounds pretty, when we talked about it yesterday, it sounded easy in the sense of it. We didn't get into any of the details. And we're not going to get into the details of the rules, but we are going to get into some examples that will have you some sense of feeling what that's like. Richard Landsberg from Nationwide Financial, he's been involved in these rules from the perspective of a financial services company. Steve McCaffrey from National Grid is involved from the perspective of the plan sponsor. Rich Helmreich, I hope I got that right, from Porter Wright, is in a law firm, and he's involved with the legal system in helping a variety of clients think about what does this mean to me and how do I deal with it. We've also asked the panel to be very mindful of the individual as they think about it. I also want to say about the panelists, you have some bios in the material, but we all have a shared experience. Each of us has served, and I currently serve on the ERISA Advisory Council, and that means that we've had to think about the issues facing us from the perspective of all stakeholders, and hopefully each of us has a greater sensitivity to the range of stakeholder issues. A little more to tee up the issue and just think about what I heard yesterday and have seen in the papers is that when we think about advice, we're thinking about the individual, what happens one-on-one, but we're also thinking about the employer, and because so much of the middle market, the employer may be the most practical way to deliver advice. We heard some about that in some of the papers yesterday. And in ERISA plans, we have an additional set of rules that are different from the rules when you have that individual advisor. And our panelists are particularly going to talk with us about that. We really didn't hear much about that yesterday at all. Also, as we tee this up, I want to think about that there are two different sets of messages or things that guide action. We think about this idea of advice. And in the paper that I did with Kelly Hewler, Kelly's paper, we talked about active guidance and structural guidance. And I think we need to remember, we talked about that this morning in terms of defaults, just how important the system structures and architecture are as well. And the fiduciary issues really go to both the structural and the active advice. Another thing that I heard yesterday that made me think about this, and a slide that I didn't see, but if I had seen it, I would have wanted to borrow, is in the last part of the paper from Bromberg and Cackley. There was a great chart that looked at the investment advisor, broker-dealer, insurance agent, and how these three separate sets of people, except they might be the same people that have multiple hats, are subject to fiduciary and suitability standards and different suitability standards when they're working with the individual. And if they're now working with an employer plan, they don't lose what they're subject to, but they get subject to more sets of rules. So that really brings us to, I think, a very interesting set of issues. We may have more to add about what we heard yesterday, but I'm going to let us go right into some interactive discussion. And we're going to start out with what sounds like a really easy question, but turns out to be not so easy at all. What's the meaning of a fiduciary, and why is the idea of fiduciary so important to various retirement system stakeholders? You heard yesterday about how there have been moves for years and years and years to make more people subject to these rules, how there's a lot going on both on the retirement side and the individual side to do that. But we thought we needed to go back and talk about what is this all about to be a fiduciary.
Good. So the answer to the question, what is a fiduciary, really depends upon what type of an arrangement or plan that you're talking about. So as Anna alluded to a moment ago, for individual accounts, brokerage accounts, bank accounts, individual insurance contracts, the term fiduciary means something very different from what we're going to talk about a little bit here, which is employer-sponsored plans that are subject to ERISA. ERISA is the federal legislation that came about in 1974 that governs most employer-sponsored plans. And the answer to the question, what is a fiduciary, is kind of a complicated one. It's been litigated countless number of times, but it boils down to, in essence, that whoever has the discretion or power or control over various aspects of the plan is the fiduciary. And so it can be a named fiduciary like the employer, or it can be a de facto fiduciary like an investment advisor. And so that's where that sort of question mark that overlays this results in some litigation.
Okay. Well, yeah, a couple things to set the ground rules. Yesterday there was a lot of talk about fiduciary standard, and you kept hearing the phrase investment advice. And to anyone on the legal side of advising plans or vendors or participants, they mean certain things. And so a lot of what we saw today, especially with the Federal Reserve Bank and the ACO, education, guidance, and advice were put out in a pronouncement by the Department of Labor. They have distinctive meanings, and that's still good law. But investment advice it's different under fiduciary standard than it is under ERISA. I liken it to, think of ERISA fiduciaries as being with the capital F, and fiduciary standard with the little f. And I'm not being condescending, but fiduciary standard under ERISA was the first attempt to codify trust law back in 1974. And it has specific things and requirements that the fiduciary must do that doesn't exist under fiduciary standard. As you all heard yesterday, fiduciary standard, best interests of the individual being advised. ERISA holds out that the fiduciary they have a duty to function in a capacity exclusively to provide benefits for the participants. There is a duty of loyalty. It's almost like there's a heightened scrutiny to an ERISA fiduciary. There's only 3 types of fiduciaries in the statute itself and under different sections, and there's a new one, a limited scope one that the Department of Labor created for participant investment advice provided by a plan to its participants, and that's called a fiduciary advisor. All of the fiduciary requirements of the statute operate under the idea of prudence. And the reason I go to that issue is we've always traditionally thought of the prudent process as a prudent investment process, a lot of what has been talked about here. But now I can see where everything has been codified and regulated, the industry has matured. And so we're now probably on the precipice of not just prudent investment process, but something to what Andreas mentioned the other day, qualitative advice as opposed to just quantitative, the prudent plan operation process. So it extends and probably will continue to extend beyond the scope of just prudent investment process. And that's all I had on that to open it up.
Okay, and I'm counsel to our fiduciary, which are two committees that have been delegated by the board of directors of our corporation to be the fiduciaries. And what that means to them, that means personal liability for any action they take as a fiduciary to the plan. What their role is and what their responsibility is to the participants and the beneficiaries exclusively. As Rich said, duty of loyalty. Their loyalty is to act prudently and loyal to the participants and beneficiaries. If they don't do that, they are subject to lawsuits. They're subject to claims being filed against them. They are subject to personal liability. Anna also mentioned the participants. When they're acting for the participants, but we also have responsibility for the participants so that they can make their prudent investments and so forth. And you heard earlier we have target date funds and other selections. All that when our investment fiduciary is looking, they have to look at those investments and try to reasonably explain to the participants in plain English what those investments are. Recognizing, as Olivia talked about earlier, and as I've had dealings with Olivia before, financial literacy is not at a premium. Most of the participants do not understand what they're investing in. They don't know what a stock is. They do not know what a bond is. They don't understand that they don't have financial literacy. The numbers are somewhere around 15% of your participants might have some financial literacy. So the fiduciaries, although they're supposedly giving the selection to the to the participants, they are really acting on behalf of those participants. They know that they have responsibility, and that's what keeps them up at night.
Yes. Do any of you want to comment about why fiduciary is so important to different stakeholders? And I guess I'd like to expand on the plan sponsor question too. Are there some people within the plan sponsor that are more affected by the fiduciary requirements than others?
I guess when it comes down to it is you're looking at, we recently converted our plan in 2010. All participants, we have people, National Grid is the electric and gas utility. We had participants who are linemen coming up to us and calling us communists because we moved from a active sleeve of investments to a passive sleeve of investments. We took away their risk. That was what they viewed it as. Is they also, most of our linemen have a defined benefit plan, a set plan, a set annuity, a fixed annuity. They believed, and this was said to us in a lot of employee meetings, that this was play money, that we are allowed to use this for our investments to buy our boats and our vacation homes and so forth. They said that we went from 20 investments down to 5 investments possibilities. I talked to my financial planner. My financial planner says you don't have enough risk out there, you don't have enough opportunity to invest. And that's where it's coming from, is the investment managers, they all are fiduciaries. The plan fiduciaries are responsible for making the investment selections. The financial planners, they're not. They're paid a fee indirectly by a participant who decides, if I'm going to go out and buy a specific investment, I'm going to go to the financial planner. He's going to tell me where to invest. He is not a fiduciary in that context. He is on the retail side of the account. The participant selects him individually. We don't recommend them. So in that context, those are the different stakeholders from the plan sponsor side. Do we have to worry about it? Yes. Could it possibly be where we have people telling them, leave money out of our current plan situation, move it into the IRAs? Yes, that's a potential. Do we do that? No. That's a stakeholder issue.
Yeah, the concept of fiduciary is the highest standard of trust under the law. And so the different stakeholders will have different roles. Now, one of the things that ERISA allows a fiduciary to do is to delegate responsibility. Now, they will not be able to alleviate all their responsibility except in one situation that I can remember, 338. But by and large, you may have the ability to mitigate your risk as a fiduciary, but you're not going to get rid of the idea that you're a fiduciary. So you'll have, potential for investment advisor to be a fiduciary, the responsible plan fiduciary of the plan is still a fiduciary, different fiduciaries with regard to, let's just say, investments. And then it can carry over to other areas of the plan as well. So you're starting to hear the word fiduciary used like a term of art because of the regulatory agenda that was proposed beginning in 2010 and has now come home full boat. And it's almost like people are starting to lose a sense of what fiduciary actually is. So keeping in mind that it is the highest standard of trust under the law and that you cannot, for the most part, alleviate it entirely from dealing with the plan, what it does is have that heightened scrutiny with regard to the actions of people under that moniker that does not exist anyplace else in the investment or financial planning world.
And if I could just jump in once more to my point, and to Rich's point, I think if you went out and asked 100% of the participants who the fiduciary is, the majority of them would not be able to tell you until they had to file a suit against you or went to a lawyer and asked them about some issue they had. Then they suddenly find out who the two committees are at our company, who are the fiduciaries.
Right, and so the answer to your question, Anna, I think, who are the stakeholders? Obviously, the participants are the number one stakeholder. But then who is the fiduciary depends upon the employer or the plan or the arrangement. And it is very different in different circumstances, right? And so that kind of ambiguity, sometimes it's the employer, the corporate entity perhaps. Sometimes it's a committee of individuals who are appointed to pick the funds for the 401k plan or help to manage the investments for the defined benefit pension plan. Or sometimes it's outsourced to professionals, or sometimes it's outsourced to a trust company, but the trust company says that they're not the fiduciary, right? So all of those are potentially ambiguous situations. And so what does that produce?
One other thing, I'm sorry.
I think that produces a situation where this law, which has the best of intentions really to protect participants and beneficiaries and produce the greatest type of system and the highest level of protection under the law, as Rich said, produces a law of unintended consequences, right? So some of the stuff we've been talking about here the past couple of days. Should you annuitize participants' benefits? What you will find is that employers are running away from that, right? Because picking an annuity company, an annuity provider that's supposed to be around forever for your participants, the next 20, 40, 60 years, is a really tough decision. And who knows what the life will be like 1 year or 5 years from now, let alone 20. So the regulatory scheme is driving employers and fiduciaries away from that.
So, Rich, what you're saying is that fiduciary requirements are basically a deterrent to people doing things that might be good for participants in some cases.
Yep. And to this morning's presentation, right? Investment advice is good. Financial literacy is low. We all know that. Although this morning's presentations are very enlightening, unsolicited investment advice, maybe not so much, but employers, I would submit that employers are hesitant to provide investment advice because it can carry with it fiduciary liability if they are in the business of giving advice.
And so when you say the stakeholders, want to tie it back together, they're under the statute itself, there's a plan administrator is a fiduciary by statute. A named fiduciary, or what we think of as the investment advisor fiduciary, the new definition of fiduciary you've heard about, that's another area of being a fiduciary. 338 investment manager under the section, and the new fiduciary advisor. And encompassing that, other than the four that exist by codification, has always been the idea since ERISA came out, that by your very function with the plan, as to what I think Steve alluded to, discretionary management of assets will throw you by your function under the umbrella of fiduciary conduct. So you can see where you can get different people doing different things, maybe with regard to the same element of the plan being a fiduciary.
We had a question over there, Andrew, maybe can we have a mic for Richard Che?
It's as much a comment as a question, but I'd be interested in your observations. For those of you who aren't familiar with ERISA, I think what you'll find ironic is with the beginning, at the beginnings of participant direction, what a lot of plans did is they actually made the participant the named fiduciary responsible for allocating the assets in their account among the options available. And anyways, I throw that out there as a bit of an oddity, but I think it's demonstrative of the point you were trying to make, Anna, which is most people with fiduciary responsibility, potentially with it, are trying to run away from it and pass it off to someone else. And in that plan design, it was being thrown back to the participant.
We have several other questions. I'm going to take several questions, and then we're going to go to 4 big developments, and then we'll come back to a little bit about what we think the future is changing and more questions. But we'll take a couple of questions before we move ahead.
Sandy McKenzie, AARP. I wanted to ask the panel if they thought that a safe harbor provision could be formulated that would deal with this problem of the reluctance of plan sponsors to offer annuities.
A safe harbor, meaning something like the Department of Labor issuing protection that if they did X, Y, and Z, there would be no fiduciary liability?
Yes, correct.
Sure, that would be helpful.
I think that's a really interesting question, and for years we operated under the rule that if a responsible plan fiduciary was going to make annuities available under the plan as a potential option, they had to choose the best and safest available annuity that was out there. Now, what does that all mean? And Dana came and testified to us, and I think that, it was an old rule. It was back in the 70s, and now the Department of Labor has issued, and I can't remember exactly when, but they came out with a proposed rule on what your due diligence requirement is. And so I think maybe we might be moving towards something like what you're talking about, because they've certainly made it more palatable to going ahead and using an annuity option rather than having to choose the safest and best available annuity out there. It's not out of the question. It's a good question.
I think you raise a really good question, and it's in many of these areas where there are unintended consequences, you can make it easy or hard for plan sponsors as arranged. And it's frequently on the hard side rather than the easy side. We have a question back there.
So, in light of all
yourself.
This is David Lakes from Harvard University. In light of all of the developments in terms of the new regs, there's a fundamental question that plan fiduciaries now face, which is where to go for independent advice to plan participants. And I want to lay out 2 alternative models and get the panel's perspectives on these models. So one model is obtain independent advice from some organization that has absolutely no connection to the asset manager, to the asset manager provider. So that would mean, say, with the Fed, we saw they went to ICO, if I'm pronouncing it correctly, which presumably was not in any way connected to the asset manager. I don't think Goldman was there, was managing the assets in that plan. Another model, which I think is much more commonplace, is to have the provider, Fidelity, Vanguard, etc., offer some advice service which they've created in compliance with the DOL regs, which is arm's length from them in some sense, but still part of the Big Ten. So it's a Fidelity service, say, or it's a Vanguard service, or it's a TIA CREF service, but it's inside their organization. They've complied with, or at least they report that they're complying with the new regulations in terms of independent advice. But of course, there's concern that there are implicit or hard to recognize conflicts of interest. So how do you think about this fundamental question that I think all fiduciaries are now facing, or all plan sponsors are facing, which is what should the source of advice be, and is it okay to go to the provider of the asset manager for advisory services, which are presumably okay, but one worries about these implicit problems?
Well, the first thing is you have to decide what type of advice, because under one section of fiduciary, you're providing investment advice to the plan, the plan itself, the responsible plan fiduciary. The investment advisor under Section 321 would go and say, here's the core fund lineup, like Steve was talking about they changed to. This is what we think your people should be invested in. And then it becomes the decision of the responsible plan fiduciary to either accept or reject or make changes to keep some of that, what have you. I think what you're getting to is the participant investment advice reg that goes to the issue of fee leveling or the computer model. And the issue under the computer model, while it's kind of been a little bit stalemated, is when the DOL, I think, and this isn't nationwide, this is my opinion, and all of my opinions, nothing to do with nationwide, but they write them intentionally vague. And that's not a bad thing, because if you try to button it down, this is how you're going to do it, you're exclusionary. And I've heard that from administration to administration, and I think that's a good thing. But one of the issues is who certifies the model. And the model has to be certified to be used by Fidelity by an independent party who's expert within the framework of modern portfolio theory, et cetera, et cetera. So if they got a certification from somebody who professes to have those credentials and was chosen through a due diligence process, it would be okay to be used. I think there's going to be a whole cottage industry that springs up with regard to this. Not only who certifies the model, but who's going to actually provide the advice. I don't know if that's an answer to your question.
Can I just clarify the question? So I'm interested both in the legal liability, but also in your views about whether there are implicit conflicts of interest despite certification.
And I could, Rich, and I would
probably are.
Before you answer, also, could we back up just a second and explain on the investment advice what's the basic development? This is one of our 4 big developments.
Well, you're probably better able to answer that. I mean, you wrote extensively about the PT.
Oh, and I want to tell everybody that these gentlemen prepared a really good background on the legal issues, and it's in your books. But we thought that having an interactive discussion and people a chance to interact would be good, and then you can study the legal issues when you go home.
So the short version of that answer is that in the very final section of the book, it's under D. Am I on? Yep. There have been a series of pronouncements from the Department of Labor, primarily, helping to differentiate what constitutes education versus advice. And the key elements, this is what you're asking,
Yes, exactly.
Is that advice carries with it the fiduciary liability that we've been talking about. And that's a fiduciary function, and if the advice is not prudent, doesn't meet the standards, isn't for the exclusive benefit of participants, then whoever is providing the advice can be held liable for it. Which is why I said earlier, employers are shying away from giving advice. However, to help encourage employers and other fiduciaries to allow for education, the Department of Labor has issued a number of pronouncements that say that if you do certain things and meet certain requirements, then it will not be a fiduciary function, and simply educating your participants, including giving specific individualized advice, or a computer model can be educational and therefore not carry the fiduciary liability.
So the computer model carries with it a couple of interesting things, just like I said in the beginning. There's guidance and there's education under a pronouncement by the department. That is not considered to be fiduciary conduct, okay? And a lot of what we heard here is education and guidance. Fiduciary advisor under the new regulation is a fiduciary action appointed by the responsible plan fiduciary to provide advice. The computer model is one way of delivering that advice, but it's not to be confused with a computer model that actually is only providing education or guidance. So sometimes these things are very fine stratified across the board, but to your point exactly, because my brain, I'm having a chemo moment, I think, but you cannot drive. There is a strict prohibition as a fiduciary advisor to driving towards proprietary product. So if Nationwide's providing advice or Fidelity's providing advice, you're not allowed to drive everything towards a Fidelity fund. So they saw the effects of conflict of interest. It was a very hard project that the department undertook because Congress abdicated the whole thing to them. But I think by and large, they did a pretty good job within the framework that they had to deal with. And now, is every conflict taken care of? That'll probably be taken care of by DOL advisory opinion or bulletin that further clarifies like the entire regulatory process functions. But they saw the potential for conflict and dealt with it, what I thought was in an effective manner
Can I just add one more thing? It's also not a fair question unless you also say, and who's supposed to pay for it? Right? It would be a wonderful world if we could drive everybody to independent advice that's completely unconnected with the plan record-keeping system. And none of the mutual fund providers will be connected to any of the advice. And it would also be wonderful if we could get all of that for free, but we can't. So who's going to pay for it? And it's either the employer for most plans, or it's going to be passed through to the participants, which then you have to ask the question, is that for the participants' best interest to have them paying for this independent advice, which kind of leads to the discussions this morning. May or may not be.
And final to your question, they've always told us you don't want to see how the sausage is made. When the working group came up with the idea of participant investment advice, by the time it got up to the Hill and got back in the hands of the department, you really didn't want to see how the sausage got made. And that's why I say the Department of Labor did a very admirable job when Congress just says, oh, here it is in PPA 06, and just dumps it in their lap and deal with it. And it didn't even look like the report they got from the working group.
So you're basically, what I'm hearing is you're comfortable letting a single company play a disproportionate role as asset manager, as record keeper, and as the ultimate organizer of the advice, as long as it meets, of course, the DOL regs. So that's not a red flag for you. That's the new system.
Personally?
Yeah.
I think there's inherent conflicts that I can't even verbalize between functioning as the core lineup provider and giving the advice. If I was in Rich's role as counsel to a plan, I'd like to see you're providing the financial vehicles to invest in and a separate party doing the participant investment advice. But I think it's possible under the rules as they exist and are proposed to do both. But trying to keep
for by whom?
But most of what I've heard is paid for out of the account, disclosed by the participant.
It's a red herring because if the asset manager provides the service, then it's in the fee, and if the asset manager doesn't provide the service, then presumably you negotiate a lower fee, and you do some kind of either revenue sharing or independent payment from the plan participants for the service elsewhere. So it's just a matter of cutting up the costs and allocating them across the different elements.
Yeah, I think your presumption is not true in the real world, though.
I'm on an investment committee. That's what we do. So it is what's happening.
Okay, I'm going to go on to Matt Greenwald. We have several other hands, but we're going to take a couple more questions, and then I want to go to the three key developments, and we'll go back to the questions.
Thanks. Matt Greenwald, Greenwald & Associates. Two brief assertions, then a question. One, plan sponsors can't shed all their fiduciary responsibility.
Right.
Second, there's a strong body of evidence and expert opinion, including we heard last night,
that annuitization increases financial security for almost all people at retirement. Question, do plan sponsors who don't offer an annuitization option or guaranteed stream of lifetime income open themselves up to legal challenge for failing to provide something which is in the best interest of their participants?
The short answer to that is no. Failing to provide an annuity is not a breach of fiduciary duty. It's a settlor function, not a fiduciary function. So plan design is not a fiduciary function, right? Making a 3% contribution instead of a 10% contribution is not in the participant's best interest either.
It would be in their best interest to give them a defined benefit plan, but that's not a fiduciary.
There's responsible selection and monitoring of the lineup and broad range, but that doesn't extend to annuitization.
Okay, I think that for me, as an actuary and a layperson, there's a really important couple of messages in this discussion that what we would think about from a common sense policy point of view, if there weren't rules, is really important. That's not necessarily what's in the law. The law says the law draws a box around what's in and a box around what's out, and these people interpret it. And you might disagree that that's the right place to draw the box, but it's a set of rules that make this box not common sense. Is that?
Yeah, well,
that's legitimate.
Okay, we have Stacy?
Yeah, so we've heard you talk about the different duties of care, loyalty, prudence.
Yeah.
What I'm not hearing you talk about is the duty of care around diversification and minimizing the risk of loss. And, Stephen, maybe to you, if you think about your plan and having 5 investment options and getting people to their goal, so focused on outcomes, and minimizing the risk of loss, how do you square those? How did you think about it?
It came down to I'm getting a vibration here. It came down to looking at whether we wanted to go. We have 20,000 employees. We have clerical. We have union. Those union linemen who probably make more than I do in a lot of instances. And having to try to come up with the best solution for the best group of individuals, 20,000 strong. And the initial investment was, okay, we're going to go just core passive investments, or we're going to go in active sleeve investments. That may happen. We also have target date funds, twofold, both active and passive, and gave anybody who wanted to go on an active side, they could. We looked at the possibility of managed accounts. We had the managed accounts, recognizing, as I said earlier, that the take-up rate was 4%. We actually took that out because we realized it just wasn't valuable and people weren't willing to pay for it. It really comes down to is, okay, did you give people the diversification they need? We believe they did, and we believe they have it. We have people pushing back on us now. A lot of our union employees are pushing back. As I said, they call us communists. But we have a lot of union participants. One specific union is very vocal, saying you need an active sleeve of core investments, and we're looking at that. But for the masses and for everybody involved, and recognizing that financial literacy, I truly believe, is the biggest issue that everybody should be thinking about, that most people don't have it. To give them 20 investments, to give them 100 investments, to go to law firms that have 500 investments, it just makes no sense.
I mean, Steve, wouldn't part of the answer be that each of the investments provides the diversification that's required?
Oh, no question.
Well,
under ERISA?
And I think actually David Lipson, who was speaking before, is one of the people who's done research that shows if you give people too many choices, for many people you've effectively taken away their ability to make choice in a reasonable way.
Absolutely.
I actually heard yesterday in a different context, it's the law of 3.
The day of the 300 fund plan is over. It's all going back to like 10, 15 funds at a crack because that's all anybody can absorb. And how many do you need? But
Sheena Iyengar is the author of that particular work, but I endorse it.
So we have. We're going to take 2 more questions over here, Judy, and then first in the back row here.
Well, one of the comments that I wanted to make, Steve kind of responded to on the question of who pays and what are the costs. I was really encouraged yesterday by what Jason said about what the cost of their managed account services are, because it sounded, he said like 30 basis points and maybe less depending on the size of the group. Once again, we're back to the bigger you are, the bigger the employer is, the more that they can offer. There is a difference in terms of who pays. If it's just in the overall management fees, then it's allocated to every account in a certain way versus charging the individuals who utilize the thing. I found as a fiduciary of a profit sharing plan covering 1,000 people, our investment or our vendor said, oh, our education service is free. Well, it can't be free. What are you going to give us in return? It's free. We really don't charge for it. Or our advice service. That was after he confirmed a year and a half or 2 years ago that it met all Labor Department rules before the rules had been issued. So, and this was, major fund family. But it is very hard to push for any kind of relief on those auxiliary services that they say are free and those they charge for, as opposed to clearly charging for an independent advisor. On the other hand, I think it's very clear that an independent advisor is the ideal way to go. And it's the American way to say, well, disclosure solves the problems. But it's always struck me that if you say to a participant, look, my company's going to make more money if you choose this investment, you should know in advance about that. By the way, you should choose this investment. What is the participant supposed to do with that disclosure? I just, if it were possible for the independent service to be provided, it just, unquestionably more valuable. But I think the managed account service is more valuable given everything we're talking about.
It can be, but it's not without. Change is constant and it moves at an increasingly high frequency speed. And so where, like, you go back into the late 80s, the debate about can you have participant-directed accounts, that took about 7 years before it was open.
No, I'm just saying that is the default.
Oh, I understand.
People don't have to take the advisor's advice. The advisor is doing it.
Target date funds and separate managed accounts, by and large, the providers of such will say that they're not a fiduciary, but that they're merely advising to the plan what they have. But the operation of the target date fund or the separately managed account itself involves discretionary management of the assets contained within the pool. And that, therefore, puts them under the investment manager label, which is a fiduciary. So that's going to have to get resolved or taken care of in their mind. But I agree with your point that they're a very useful tool. But you see how these things crop up. Like target date funds are the answer. Separately, yes, they are from a policy perspective. And do they do the most good? My opinion. But then as a lawyer, you go, wait a minute. On the legal side, they're making a decision. They're doing it on their own with regard to the construct of the fund or the account itself. That's a wholly different level than just being an advisor. So that's the world we play in every day, which is why I have no hair.
I hope we've given you some feeling for the complexity of some of the issues that people need to deal with. What we want to do now is there are 4 big picture issues in terms of current developments that we've had where they have a big impact on ERISA. These are all ERISA plan fiduciary issues. These are not issues related to the individual that's giving advice, nowhere near an employer. We've got now the slide up here listing the 4 big issues, and we talked already some about participant investment advice, and maybe we'll see if we have any more that we want to add on participant investment advice, and then we'll go up to issue A. Does anybody else want to add anything on participant? Okay. Let's go up to A, fiduciary update, and Rich, you were going to start our discussion about.
Briefly on that, I think it's important to know that ERISA is one of the most well thought out statutes that was ever put. Someone pointed out to me a couple of years ago that it is the least amended statute in the United States Code annotated. So what has occurred since 2010 with regard to ERISA, with regard to disclosure, vendor disclosure, and participant disclosure, and new definition of fiduciary, you're talking about a statute that came into being when Gerald Ford was president. And there's been a lot of innovation in our industry. When Gerald Ford was president, defined contribution plans were pooled, and there were annuity options attached to it. Now we're in a participant-directed world, no annuity options, etc. So the Department of Labor's regulatory agenda is really a response to the innovation of the capital markets as it applies to retirement security. And so the fiduciary update, the problem is who is a fiduciary? The new definition, the 321 statute as they call it, is an answer to a advisory opinion that was issued in 1975. And it had a 5-prong test. And people at Labor said, you've got people playing around it, hiding behind the name of consultant. And so what they did was they simplified it. It's not final, it's in proposed form. But what it actually, to me, it makes it very easy. You provide advice for compensation that is relied upon. You're a fiduciary. So constructing core fund lineups, et cetera, et cetera. And that's what you see. And so for people, it kind of levels the playing field, and you don't have vendors or service providers playing games or making it easy for them to play games and then claim, oh, I have no liability for this. This is serious stuff for serious people, and there should be accountability. And that's what I think the new definition of fiduciary is all about.
And so, adding on to that, there were proposed regs back in 2010. Those have been withdrawn. There are people here who understand a lot more about what's going on inside of the Department of Labor, inside the Beltway than I do. But I think those have been withdrawn. They were supposed to be reproposed and issued later this year. I think that may be on hold until after the election. It's hard to get anything done inside Washington these days. But that new regulation would have expanded what the historical sense of what a fiduciary is to from the old historical standard of having actual discretion and power related to the plan investments or other administrative function to more of an investment advice concept.
When you look at your materials, and again, I put together a slideshow. Rich really helped out on it. It had like a billion slides in it, and then we're going to narrow it down. But you'll see a grid there that he came up with that between 321 and 338. Keep in mind, 321 is making advice, and it's a non-discretionary action. The final decision to go with a lineup of funds is based upon the responsible plan fiduciary who works for the plan sponsor. The 338 in the grid, that's a section of ERISA. That's the investment manager, and they have total discretion over the assets, when to buy and sell, etc. So when you look at that, that's the only thing I wanted to say is you will not see that delineation there. So I'll just expand on that. But
so then the other kind of practical comment I would make on that is that there are a lot of people here who either are with or work with financial institutions. And the problem that I see in the marketplace is that there are a lot of situations in which 401k plans especially have directed trustee arrangements. And so the financial institution, the record keeper, is saying that we're not a fiduciary. We want none of that liability, and yet they're the ones that are, in essence, picking the funds and making the investment advice and edging up upon that borderline, in some cases, for smaller employers especially, going over. They're doing it all. The employers are out making their widgets in the factory, with their 100 employees, and they're busy, and so the investment guy or gal comes in and takes over and does the employee meetings, the enrollments, and the investment selection, including what plans are on the platform, right? And so in those situations, I think they're standing behind an agreement that identifies their responsibility not exactly how it is. So
I have a question for you all about this. Is there something about the proposals that the DOL made or is likely to make going forward that changes the way individual retirement accounts fall in this spectrum of what happens to who's under what sets of rules?
hugely, yes.
Yeah.
Yes.
Can we talk about that a little bit?
So the new proposed regulations that were issued and then withdrawn and may or may not be issued again would have expanded the ERISA fiduciary responsibility to IRS.
Okay, we've got Joe from the Department of Labor. We're going to recognize Joe.
Okay.
Yeah, so let me comment a little bit on what the proposal from October of 2010 would have done. And I also should say that my boss, Phyllis Borsey, it is still currently her intention to issue a new proposal. I think I can't tell you what the exact timing is likely to be. But.
I think you'll have to talk louder.
Oh, sorry. So there was a lot of confusion when the proposal was issued in 2010 about how it would impact IRAs. And so on this one point, I do want to jump in and make sure that it's clear. Having fiduciary status has two different pieces to it. One piece under ERISA and one piece under the tax code, right? Under ERISA, you have these duties we've been talking about of prudence and loyalty, and you have liability. That only applies to job-based plans, right? But you also have something that we call the prohibited transaction rules that go to whether a fiduciary can self-deal. So, for example, whether the person giving the advice can also have an interest in the products that they're advising on. And that exists not just in ERISA, but also in the tax code. And so extends not only to job-based plans, but also to IRAs. So when the question comes up, would the proposal have affected IRAs? The answer is yes, but it would not have extended ERISA's fiduciary standards to people advising IRAs. It would only have extended the prohibited transaction rules. So there would be no new duties of loyalty or care and no liability for those advisors. But there would be new obstacles for certain kinds of compensation arrangements that might connect their advice to their own compensation. So there was a lot of misunderstanding around that at the time. And the one other thing I'd say, of course, is that it's not as if any of these rules for fiduciaries were new under the rule. What the rule was doing was just broadening the definition of what kind of activity gets you under the umbrella of having to act like a fiduciary. So starting with the statute in 1974, if you gave investment advice for a fee to a plan or an IRA, you were a fiduciary. But the department issued a regulation that sort of narrowed that. It set forth these tests you had to meet, or it wasn't really investment advice. So, for example, if it was one time, it wasn't investment advice. It had to be a regular basis. And then there were other things like that. So what the proposal would do is relax some of that and go closer to the original statutory language. So more activity would be fiduciary in nature.
Okay, I'm going to be sensitive to the fact that we have people that have all kinds of different connections to plans here, and ask somebody on the panel or Joe to just explain that prohibited transaction. I think that's a word we haven't heard much about in the last day or so.
So a prohibited transaction is any type of enumerated transaction between a plan and a party in interest. And the plan is an easy concept, but we're talking about an employer-based plan or an IRA under the tax code. And a party in interest or a disqualified person is the employer or a parent company of the employer or a significant owner of the employer or subsidiary of the employer or an employee-based organization like a union. And so those sorts of parties in interest can't be engaging in transact or a fiduciary, another important one, or a service provider. And those parties in interest can't engage in a transaction with the plan that will produce self-dealing. And from those rules, those prohibitions, there has been countless number of pronouncements called prohibited transaction exemptions issued from the Department of Labor. Some of them are individual and some of them expand and are relied upon by can be relied upon by everybody, that make certain types of arrangements okay. And so what we're talking about here are perhaps revenue sharing arrangements or fees that a fiduciary might get. They can be reasonable, and there's dozens and dozens. Commissions and certain arrangements are okay, but
I mean, it looks kind of not appalling, but just almost overwhelming. And the fact of the matter is the industry's grown up. When I got into this business 32 years ago, everything was IRS driven. Everything was about plan design, and it lasted about 10 years. 1981 Act, the 82 Act, the 84 Act, the rewrite of the code in 86, and 3 OBRAs that came after it. Everything about plan design. And then somewhere about 88 to 91, because revolutions they're always messy, the next phase came, and that was about what are you doing with the money? And so all these things in ERISA about fiduciary responsibility finally bubbled to the surface. And so we spent from like 92 to 2006 dealing with fiduciary responsibility, benchmarking, doing a good job as an investment committee, having your investment policy statement. And now we're in the last phase, which is transparency, leveling the playing field. Everybody's on the same wavelength. Everybody has the same rules. And you think about any other industry, whether it's auto or cereal or they all go through that. And so the retirement plan business has gone from, pooled arrangements, both DB and DC, to participant directed, and the regulations are growing up with it to reflect the 3 revolutions. Plan design in the 80s, fiduciary responsibility in the 90s to about the mid-decade here, and now we're into transparency, and that's how I look at it. The glass is half full to me,
Rich,
just like this.
You brought us to what I think on our and we're running very close on time now, to our last 2 big picture issues in terms of new developments, really building on what Judy said before, and that's transparency. And do you want to just mention do we want to mention the developments with regard to new disclosure requirements and bigger disclosure requirements?
Well, sure. I'll kick it off. This is very timely because there are a pair of new rules that come about through ERISA that are kind of a 1-2 punch in transparency. The first set of rules are the service provider disclosures, and those are disclosures that are required from service providers, financial institutions, record keepers, etc., to the plans. Then there's a second set of disclosures that are required from the plans to the participants. And so the idea behind the rules is that participants will ultimately be getting a lot more information about their investments in 401k type plans, 403b plans, other plans in which they are participant-directed investment vehicles. The purpose behind it is that there is this kind of common notion that participants don't understand enough about their investment choices. They specifically don't know enough about the underlying fees and that are embedded in the different investment options. And so if you give the participants more information about them, then they'll make wiser decisions. Query whether that's true or not. We'll find out, I guess. But and so this is timely because the first level of service provider disclosures are required by the end of June, and then the second are required in August. And so service providers, plan administrators, and employer plan sponsoring plans are scrambling right now, in our experience, to make sure that they're going to comply with these regulations.
You probably got real experience with it.
We do. And also to the point that Joe raised earlier, this is not something new. This is something that was in the code, the requirement as far as a fiduciary, determining that the contracts and the transactions they deal with and into it on a regular basis are reasonable. What's happened now is it has been codified in regulations, or it's been promulgated in regulations, and now tells the fiduciary what he needs to do, what she needs to do in order to reach out to the service providers, providing advice, rendering services to them, rendering services to the participants, and so forth, if the plan pays for that, direct or indirect compensation to those providers. One of the things that comes out of that now is we're in the process of sending out to all of our service providers that are paid for by the plan on the DB side and also on the DC side, but the DB side, the requirements of the statutes, which now are alerting to the fact that these exist when some of these investment managers didn't even know what they were and didn't know what they had to respond to and why they had to respond to it. So that's opening up some interesting questions. The requirement as of July 1st, if we enter into, renew, modify any contract, any arrangement, any agreement that we have with our service providers, it's over $1,000. We have an obligation now to ensure that it's reasonable under the regulations. Well, that's no different what was in the code already, the ERISA originally, as far as the manager or fiduciary responsible for looking at that to make sure that they were reasonable anyway. So it's not something new, but what it now involves us is getting boxes and boxes of paper from our providers that now we're going to have to cull through to determine what's reasonable and what's not reasonable. There is no standard, unless Joe wants to tell me otherwise, there is no definition of reasonableness in the regulations. We actually have to make our own assessment. There's going to be a new cottage industry out there benchmarking what reasonableness is. We'll see that develop. And we now have to go through that period, go through the documentation to determine if in fact our transactions, our arrangements, our agreements are reasonable. If they are not, or if we have questions as far as what we believe needs to be answered, we have an obligation to go back to those providers and ask them for information so that we can make that assessment. If they fail to do that and do it within 30 days, it becomes a prohibited transaction relevant to the service provider. We are obligated to terminate that relationship. If we can't determine from the information we get that what we have is necessary to show all the services, all the compensation, and so forth, the fiduciary is obligated to make that assessment and to terminate that relationship and to find somebody else.
We are just about out of time, so I want to give 1 minute to each of the panelists for any. We've heard there's a lot of change in the wind, and there's a lot of challenges around this. And as I said, I hope you all have you can read in the book some of the specific code sections. And I hope you have some flavor of how this impacts people. If you have any prediction about where the fiduciary requirements might be taking us, or any recommendation, just take a minute each. Maybe we'll start with you, Steve.
Sure. I think the one thing that, as Rich alluded to, and I am unknowing of yet, is what will happen when the participant disclosure hits the mailbox of the, and sometimes we can do it electronically if the DOR allows it, but when the participant disclosure hits the participants, which is the other obligation on which we didn't get to, was the obligation to get out to participants notice on when they have a 401k plan election plan that they're allowed to do. We have to provide participant disclosure of fees, expenses, and so forth, so they can conceivably look over a 30-year period and see what those fees will cost them as far as their expenses and their investments and so forth. We'll see where that comes out. One of the questions we've had when we've talked to some of our employees about this new fee disclosure is they didn't know they were paying fees. They are now getting a rude awakening that they are paying fees. They also question why they're paying fees when they thought they didn't have to. The other question is, I'm getting a 19-page document. Who's paying for that 19-page document? And why do I have to read this? What is this going to tell me? And basically we're hearing from some people, not all, that this will be something that we just throw in the trash. Because they will not know what to do with it. They don't know, as we've talked about earlier, they don't have the financial literacy to understand what they are receiving. And they don't really care to receive it other than the fact that they're going to find out that they're paying for it. That being said, I think it is going to open up the door for a lot more people. We have a lot of engineers. Our engineers will take this and go through it with a fine-tooth comb. They will start talking to people. They will explain to them what this is. So it could have a good potential. You know, so we'll see. And one of the fiduciaries who I forgot to mention as we were talking earlier is, who is not a fiduciary at all, is being a union plan, union participant plan, and so forth. If a union individual can find a shop steward or a foreman who says he knows about investments, believe it or not, that is often one of the people who they rely on when they make their investment choices. So it's all out there as far as people and what they can do. We hope this works.
Do you have a quick comment about the future where we might be going, either Rich or Rich?
Go ahead. I'll wrap it up.
More. there are more
Process.
requirements, more notices, more everything being imposed upon these fiduciaries. And never is there any less. So more regulations, they never repeal any of the old ones.
Somebody's ox is going to get gored with the vendor disclosure rule called 408B2. That's 408B2, as you heard Steve say, has been around since the advent of ERISA. What wasn't around was the methodology of disclosure, so the responsible plan fiduciary could exercise their fiduciary responsibility. Now that's there. Who shares the execution? Well, the vendors, like my company, who provides the information to a sponsor or responsible plan fiduciary like Steve, and then they go through the process of determining whether it's reasonable or not, and whether to retain the services or not. Then you go down to the 404A5 participant disclosures, and it's a methodology. This is how we want the expenses of the plan disclosed to the participants, etc. Again, probably way overdue to have it done, but that's his responsibility as a plan sponsor to get it out. Going to probably rely on counsel to put it together. So you see the shared responsibilities that move around just to understanding your role. 321, the new fiduciary, that's the investment advisor. They are advising, they're a fiduciary. Steve, as a responsible plan fiduciary, still has the duty to monitor that investment advisor. Cannot alleviate his risk, can only mitigate it. And then with the participant investment advice, it's his fiduciary decision as a plan sponsor to have it made, and then whoever's delivering the advice is within that narrow new definition as a 408G14 advisor. So if you can't just say that person's a fiduciary and that's it. And if you take away anything, plan sponsors are not fiduciaries. Plan sponsors are entities. Within every plan sponsor is the tag responsible plan fiduciary, who enters into the contract or makes the decision with regard to something. But you're probably right, more. But when you have a regulatory overhaul, you can expect that. I mean, there's only so much that's going to be in the statute or the reg. But
I want to thank the panel, and I think we've gotten a good flavor for, as we want to do more for participants, we have to be careful to do it well, and there's a big balance between making it better and making it more complicated.
A round of applause.